In various Claimants versus Mercedes-Benz Group and others, Mr. Justice Constable and Senior Costs Judge Rowley determined the outstanding costs budget phases in the NOx Emissions Group litigation at the third costs management hearing. The central issue was the appropriate ratio of legal fees to expert fees across 5 expert disciplines forming part of the Tranche 3 budget. The claimants' budgets reflected a near equal split between profit costs, counsel's fees, and expert fees, producing a combined legal spend approximately twice the expert fees, a structure the court described as a 1-to-1-to-1 ratio. The court held, applying the principle of reasonable and proportionate costs management under CPR Part 3, that legal fees ought not to approach twice the expert fees, and adopted a methodology of doubling the approved expert fees as a starting point for permissible legal costs. For loss assessment, the defendant's offer of £1,267,500 was allowed in full. For mechanical engineering, the Mercedes budget was allowed as claimed at £718,681.65, with £340,000 allowed for each of Peugeot, Citroën and Ford, and £600,000 for Nissan Renault. For software engineering, £125,000 per Alglo was allowed, save £250,000 for Nissan Renault. Consumer behaviour was allowed at £1 million at lead and Alglo level. UK vehicle valuation was allowed at the defendant's offer of £400,000. The total claimant's experts phase budget was approved at £5,411,181.65, against a defendant's total of £12,858,057.16. Quote, "This was not a reassuring explanation, and it did not meet the substance of the criticism, namely, that a ratio of 1-to-1-to-1 was itself inappropriate. Previous judicial comments have been made about an inappropriate amount of lawyer time being spent on the curation of expert evidence. It ought not to be the case that the legal fees are anywhere close to twice the amount of the expert fees required to produce the necessary evidence, let alone above that ratio."
For a detailed summary of this decision, visit tmclegal.co.uk.